All right. Good afternoon. Good afternoon, everyone. Sorry. Welcome to part two of the opening statement workshop. This is Wesley Ecke, the chair of the Education and Recruitment, and I'm joined by Miss Lori Sams. Again, she's here to join, and she's here to help judge, and she's here to help give feedback as to whoever has done the decided to be brave enough to come up in here and present what they can do. So I guess I just kind of want to start off by volunteers. Who wants to come up here and show what they got, present what it is. If not, I guess we're just going to pick. So crickets, yeah, definitely.
I'd like to help pick.
Yeah, I'll leave the picking up to Jesse. You came to listen. You didn't come to present.
Me?
Because I don't know how to do it.
Well, hey, that's the beauty of it all. You get in there and you see how how to do one. You create a story and you present the law, and then you present the facts that you're going to hear. Just three basic things, and those three basic things can take you a long way. So Jesse, go ahead and pick, I guess.
Well, I'm gonna pick Grant for two reasons. One, I know him, and also he replied in the chat crickets. So if he's gonna comment like that, I mean, sorry to call you out, Grant, but it looks like you're up first.
I thought that might be coming, Jesse.
I guess, are you in a place where you can turn your camera on? Because I'm here just in a hoodie and whatever.
Yeah. Yes, I am. I'm just messing with it right now. All right. Okay. So I took the approach of the defense attorney for Cindy Johnson. Good morning, ladies and gentlemen of the jury. My name is Grant Klingler. I represent one of the defendants in this lawsuit, Miss Cindy Johnson. Thank you all for being here today. The decision you make will have a significant impact on the rest of my young client's life. Your thoughts and opinions are extremely valuable. Your roles are the most important of the day, and I look forward to your reasonable consideration. On the morning of March 8, 2021, Cindy Johnson, like the responsible student she is, awoke to begin her preparations for a full day of schooling. While she prepared her school materials, Cindy was accompanied by distasteful background noise, a type of noise that does not help a student prepare for school, but instead permeates unease and discomfort, the type of noise that lingers and burdens a student throughout their day. That noise was the increasingly agitated arguings of Cindy's parents. It is not a child's place nor responsibility to confront parents engaged in a duel of aggression. It was through Cindy's desire for a harmonious resolution rather than any invisible responsibility that she eventually checked in on her arguing parents. Her father sat on the couch, arms folded unmenacingly, while her mother rummaged through the nearby closet. Cindy knew that this closet was used to hide her father's semi-automatic pistol, and Cindy knew that her parents spent the morning arguing. This does not mean that Cindy knew that her mother would shoot her father. Cindy actively thought the opposite, in fact, that it was impossible for her mother to even consider such an appalling act. Like the responsible student she is, Cindy left the morning of March 8th with school on her mind, not with the thought that it would be the last time she saw her father alive. The evidence will prove two things. First, my client, Miss Cindy Johnson, had no reason to believe the murder of her father was a foreseeable consequence of her parents' extended arguing. And second, that even though Cindy was aware of her parents arguing, she had no responsibility to attempt to stop this arguing to prevent the unforeseeable result of her father's death. Today, unlike Cindy on March 8th, you all have a clear responsibility. It is your responsibility to determine the fate of a student who, rather than experience another standard day of school, was subject to the extraordinarily public murder of her father. Miss Cindy Johnson is a party to this case because the prosecution wants to hold Cindy responsible for the murder of her father as if she pulled the trigger instead of her mother. You will be asked to determine whether such a judgment is reasonably fair. It is my hope that in weighing all the evidence, it will become evident that Cindy cannot reasonably be held responsible for the tragic death of her father, and to hold otherwise would go against all justice and fairness that we know. Thank you.
I have a question for you, Grant. What was Cindy charged with?
Nothing. I don't think the fact pattern said anything. I kind of just.
Oh, I thought it was very interesting that you decided that that was the person who was going to be part of the case. So I was just curious as to what you thought the charge would be. Aside from you picking an odd client that I wholeheartedly agree with you, she shouldn't be held responsible. I thought you, with a limited fact pattern, this doesn't tell you what the charge is or anything like that. And usually you go into these things knowing, you know, at least what they're going to be charged with, so you can give the jury some sort of elements. I thought you told them what they were going to do. You told them what it was about, and you told them what you wanted. You did the correct flow for an opening statement on such limited information. I would be careful about mischaracterizing evidence, because you say that he was unmenacingly sitting on the sofa, and that's not part of the fact pattern. So,
again, I apologize because the way I created this thing, I guess it was kind of up to interpretation as to who was going to be the defendant. My bad, y'all. We'll do a way better job next time.
So that was actually kind of creative that he took this stance, I think. I think he gets points for that.
Yes, 100%. I'm down with that. Okay, hey, I liked it. I like the use of the words. You used a lot of, it was interesting wordplay there. But you know, you also have to keep in mind that whenever you're talking to juries, you know, I would just simplify things. Just make it simple. Just you know, go in, you know, sometimes, you know, it doesn't have to be as eloquent as you would like it to be. And I know we're all law students here, we're all smart, you know, we're all going to be lawyers. So, you know, we tend to, you know, talk, you know, just, you know, for me, I would say scale back. I'm not sure what Miss Sams would say, but I would just like to keep it, you know, keep it simple, I guess.
I agree that that's usually the case. I didn't catch his use of anything that I thought would be difficult. You always pretend like it doesn't matter if it's in front of a judge or if it's in front of a jury, you're always shooting for an 8th grade education. That way there's you don't have somebody caught on what the heck does that mean? So that, you know, that it distracts from what the story is if you use words that someone might not understand, even who's educated. That's why you say 8th grade education. I didn't catch that you did. You may have, and maybe Wesley had a keener eye on that, but I didn't catch it. But I agree with his statement about it generally.
Anybody else have anything to say?
Thank you so much.
I'll say I really liked your pacing. I think that's like one of the hardest things to teach in the very beginning. People don't realize that, like your timing. And just your pacing of talking. Like I'm guilty of flying through it at 100 miles an hour. Wesley knows this. So like you did a great job with right off the bat. And your voice is very likable and very calming, and which is a really great thing. So you naturally have a lot of really great things on your side.
That's really good feedback. How you talk, you kept it natural. It didn't feel like you were reading a speech. It didn't feel like you were, you know, just saying a bunch of, you know, garbage. It made it so that it was easy to follow what you were saying because of your pace, your personality, and presenting it. It was very good. That was a good point, Rachel.
If law school doesn't work out for you, I would say get a job reading audiobooks for audio.
100%. There you go.
All right.
I'll jump in real quick. Grant, thanks for going. I liked how you started off, thanking the jury and talking about them. That's something a lot of attorneys forget. I would have liked to hear a little bit more law, like I said, what she would have been charged with, maybe a little bit more passion. This might be somewhere that other people disagree, but especially if it is a serious charge of a crime, there's got to be some passion there, in my opinion, if that kind of makes sense. But your style is overall good. Thank you.
I agree. Thank you. Quick question. I assume opening statements aren't usually like kept to a time limit.
Yes, they are.
What's the time limit average? Like, is it someone?
I mean, when
waiting
you're in
next to
court,
them?
in real life, it just depends on the case and the judge. I mean, some judges will, if it's a simple case, will say you guys each get like 15, 20 minutes. If it is a very complicated case, opening statements can be an hour each. So it just depends on the case, but ordinarily you're looking at it like a half hour, I guess, is probably the most you're ever going to ordinarily see.
I know for mock trial purposes, I know undergrad we had 5 minutes, but law school typically you start seeing have like what, an hour?
10,
So yeah, an hour or so to present a case. So total.
Yeah, you're not going to be able to in that length
Yeah,
of time.
so usually, I guess you would stick to like around like 10-ish minutes for an opening. So. All right, I guess who's Jess, we want to pick someone else next?
Nicholas.
Ooh, okay.
All right. Well, I don't think I'll be as eloquent as Grant because I kind of did this last minute. My father had surgery today, so but I chose the side of the prosecution, so I'll begin. Ladies and gentlemen, thank you for being here today. Today you will hear a case about one of the most heinous crimes out there, murder. On March 8th of this year, Mr. Johnson was shot and killed in his very own home by the defendant, his own wife. The day began like any other day. Cindy Johnson, the daughter of Mr. Johnson and the defendant, woke up preparing for school when she overheard an argument between her parents. When she was leaving, she noticed that her mother was rummaging around in the closet where her father kept his semi-automatic handgun. She left for school, thinking nothing about it. Little did she know that would be the last day she'd see her father alive. The defendant, Mrs. Johnson, shot and killed Mr. Johnson. Today you will hear testimony from some witnesses around seeing the crime. One witness saw Mrs. Johnson running away from the scene, and even more importantly, another witness, a neighbor, said she saw Mrs. Johnson kill Mr. Johnson. I would ask that after you've heard all the evidence today, that justice would be served and that you would return a verdict of
You froze.
Maybe bad reception. We'll give it a second.
Yeah, it looked
he's
like
frozen.
it looked like his connection had kind of gone out a little bit, so that's probably what's going on.
Sorry, Brittany. I was just trying to say that he's frozen for me.
No. You're cool.
Okay, yeah. You're back.
Yeah, I guess my internet went out. I don't know where
I think you were kind of at the end.
Yeah, you were towards the end because you said we'll see, and then that's the last thing I heard.
Okay. Well, I was just saying that after the where's that? I would ask that the jury, after you heard that all the evidence today, that justice would be served and that you would return a verdict of guilty for charges 2nd-degree murder. So.
Okay. I like it. I guess Miss Sam, do you want to go first?
Sure. I like that you told a story because that keeps them interested. If you keep, tell them a story so that they don't nap during it. I would have suggested that you let them know what the elements are they're looking for. Just because you had a witness or something, that doesn't tell them that that's how they're going to find somebody guilty. So since I was going to, before you came back and finished it up, I was going to ask you, what are we charging her with? So that's kind of an important thing that you should let them know, ladies and gentlemen, you're going to hear this, this, and this, and that will show and list the elements of your second-degree murder. And based on the evidence, you should return a guilty of, a verdict of guilty. Also, I would watch the use of do you have a roommate or a wife or anything?
No, but
okay. Just as a suggestion that we used to do is we would give somebody who was like helping us practice, or like in my case, it was my son, when I was in law school, is give them a whistle. And anytime I would say, or huh, as how people use those little ums and whatever when they talk, to stop that, they would blow the whistle. And you realize it makes you really a lot more conscious of it, other than just saying you said it again. For some reason, it's like a dog. You hear that whistle and it trains you not to do it again. So
My to that same point, my old mock trial coach in undergrad, she had a squirt gun. And she would shoot us with a squirt gun whenever we did stuff that she didn't like, whether we say it like an or like a filler word, or even we did something like mannerisms wise, like start walking around too much, or start like putting our hands in our pockets, things like that.
Yeah.
Yeah. So that's definitely great advice. And typically I feel like when it comes to filler words, stuff like that, it's us reaching for the proper words.
Right.
That's why I like to write out my opens or closes, and whatever works, I just like write it down, memorize it how I'm going to go, and that way after I memorize it, I can, from that point, if I need to deviate just a little bit, it's easier for me to do so, to reach for those words, and it helps me go along with it. So that's just my bit of advice as well.
Thank you. I'd like to comment that us 1Ls haven't taken criminal law yet, so we don't really know.
We know that. Yeah, we don't expect any of you to have this perfect. We didn't have most of the courses. I think ours was criminal too, and we had, all the preponderance of the evidence. I was learning that while trying to learn how to write an opening statement because we'd never taken it either. So I love that you guys just took this opportunity to get up here, because I can see you're nervous and it's hard. We get nervous too. And the more times you put yourself in front of us, the more practicing you do, just that's where it gets easier. And so good for you. I'm proud of you.
Thank you.
Yeah, absolutely. Going with what Rachel said, as somebody who, especially coming into law school, it's waned a little bit now, but I have a real fear of speaking in front of people. So I think that this and our future closing participation opportunity is really just to shake off those nerves, right? Kind of introduce you to who we are so you can see us and maybe become a little bit more familiar, because in the future when you're working in a court, you're going to know the judge sometimes, but also just kind of help you get that opportunity to public speak, because you probably haven't had it as much in school yet. So I don't think anybody is expecting anybody to know everything today. Right. I think we're all just super thrilled that you came, you tried to do something, and you're taking real constructive feedback for next time. So I appreciate you so much, Nicholas, and everybody else for showing up today.
Oh, yes. All right. Does anybody else want to try their hand? I see.
Ooh, Deirdre said she'll do defense.
I actually have mine also.
Oh,
I can go after Deidre though.
No, please go first.
all right.
Oh, 1 second. Yeah. So I actually did mine for the defense, but of Mrs. Johnson. She didn't have a first name, so I just call her Mrs. Johnson.
That's fine. And it doesn't. Oh, let's just pick a name, I guess.
I mean, I have it written as Mrs. Johnson, like throughout my whole
Let's
thing.
do it. Let's do it.
Paper is Mrs. Ladies and gentlemen of the jury, my name is Emily Ford, and I stand in front of you today as a representative of my client, Mrs. Johnson, who's being accused of murdering her husband. Today, you're being asked to decide the future of a woman who has suffered a grave loss, and even further, the state is accusing her of creating that loss. On the morning of March 8th, 2021, Cindy Johnson, my client's daughter, heard her mother and her father having a loud argument as she got ready for school. By the time Cindy went downstairs to see her mother and father, they were no longer speaking, as her father was sitting on the couch and her mother was rummaging in the closet where she knew his gun was kept. However, she reassured herself that things were okay, as she had no reason to believe otherwise, and went to school. Not immediately, not after 1 hour, nor 2, but after an entire day of school, Cindy went to a campus restaurant and later then saw the news, which displayed the headline, "Man Dead After Argument with His Wife." She recognized her house, raced home, only to see the police interviewing multiple witnesses who claimed to have identified her mother. So why are we here? The question that you, as the jury, must ask yourselves through this day is that if the state has been able to prove beyond a reasonable doubt that Mrs. Johnson is guilty of killing Mr. Johnson. I urge you to understand that based on the evidence that the state will present, if it is possible for them to satisfy their burden of proving without assumptions and circumstantial evidence that Mrs. Johnson killed Mr. Johnson. The state's first witness is an elderly woman who, in shock, claims to have seen Mrs. Johnson from her house, but will provide no testimony as to what she actually saw. Ask yourselves how likely it is that an elderly woman would have been able to accurately testify to what she saw from another house. The state's second witness is a woman who was jogging and claims to have seen Mrs. Johnson driving away from the house at a high rate of speed. Again, ask yourselves the likelihood of seeing a stranger's face while jogging, with them driving at a high rate of speed. Ask yourselves the likelihood of being able to see a stranger's face with them driving away at a high rate of speed. There's simply a very low likelihood that that's actually possible. As the defense, I'm not required to prove that my client is innocent. It's the state's job to prove that my client is guilty. And as I've stated, that what you'll hear today, and based on the lack of hard evidence, they will not be able to do that. If you've ever had a fight with a boyfriend or girlfriend, husband or wife, or someone that you live with, then you'll understand that many fights typically amount to nothing. A woman lost her husband, and a mother lost the father of her child. The assumptions made based on nothing short of circumstantial evidence are just that, assumptions. And I encourage you to find my client, Mrs. Johnson, not guilty of murder that she's being charged with.
I liked how you immediately showed it as being circumstantial evidence, putting the burden of proof out there, letting them know that they can't rely on circumstantial evidence. I mean, questioning whether they can rely on circumstantial evidence. You may have kind of tipped a little bit to argumentative. You speak so softly that no one would ever probably challenge that you're being argumentative, but you are, because you were directly attacking the evidence that will be shown, and that's usually for closing. Instead of saying, I don't remember exactly how you worded it, you'll hear from an elderly woman who you'll have to judge whether an elderly woman that will testify was actually able to see what she claims to have seen. You will have to determine whether you believe the jogger, whether they could actually see a car going at a high rate of speed instead of specifically saying that it's bad evidence, because then you're attacking the evidence and that's becoming argumentative. So just bring it back just a smidgen so that you're not argumentative. But I liked how you picked up those details. That was really good, and knew exactly, put it out there to the jury exactly what they were going to look for. That's you not only told the story, but you told the jury what they should be paying attention to in order to return their verdict.
I mean, yeah, I'm definitely gonna piggyback on what Miss Sam said. Have you ever done this before? I'm just asking.
I have not.
Okay. You got all the parts there. You got the story, you set it up. You talked about the law and, like, you know, what exactly the charge would be. You talked about the burden of proof, the beyond a reasonable doubt. And you talked about, you know, the evidence that the jury is going to hear. You know, again, all of that just encompasses a great opening statement, and it was really good. Like Ms. Sam said, you did kind of nudge a little bit into the argumentative side, but again, that just, you know, comes with experience as to what to do and what not to do, and basically how to frame your words, you know, going forward, so that way you don't get into that area. And it was good. You told the story. It was soft spoken. You know, we were able to, as a jury, to sympathize with your client. That, hey, this is hard on not only the child but also on her, because she just lost her husband as well as the father of her child.
Yeah, I like how you started with that and finished with about how she is suffering a loss right now. That was really pulling on their heartstrings from the very beginning. I like that.
And that's a thing that I like as well. I like, again, everybody knows here I'm a flair for the dramatic, so I like to, you know, I like to pull on the heartstrings. I like to get passionate, and, you know, with your opening, you're able to do all of that while also at the same time remaining soft spoken. So good job.
I think, like, the way Lori said it best was that, like, it came full circle. And I think that's a really good thing when you're telling a story, is to make it come full circle. And especially when you don't have a theme, it's kind of nice because you tie it back around, because you start off giving us this is this person that we're looking at, and we need to see the story of this person. And then you brought it back around to this is this person, this woman who just lost her husband. And so that was kind of nice, bringing it back around. It's a great literary tool that kind of just, like, really brings the story, you know, hits the point in, I think. So I like that.
I'll just jump in here really fast if y'all don't mind. Emily, I'm just going to piggyback off of what everybody else has told you today. You had me from the very beginning because you did start playing on that emotion. The defense side is typically what I prefer to argue. I enjoy it a little bit more, but it is hard to include that emotional aspect in there sometimes. And that's what had me drawn into you from the very beginning of it. And like I just said, it's really hard to do. And if you can find that angle, if you can humanize your defendant, that goes a really long way with a judge or with a jury. So you did a really good job with that. And I know everybody's kind of mentioned it, but I really wanted to highlight it because that really caught my attention. So good job.
I just have one thing to say, and it doesn't have anything to do with your content. I thought your content was great. This is just a tip for everybody. When you're going through your openings or closings or whatever, if you have something prepared, sometimes you might slip up, right? Like something comes out not the way you've prepared it, or you miss a word. And it can be really, like, easy to go like, oh no, I said the wrong thing, and freeze up. But you're the only person who knows what you have prepared. We don't know what you're preparing to say. So don't stress it too much if you miss a word. Just correct it and move on. Like, and that'll keep you from, like, throwing off your flow for the rest of your opening statement, which you didn't do here, but for some people that can be a really big, like, mental barrier. So just next time, if you find that you drop a word somewhere when you're in the middle of saying something, just correct it and go on with your day, because nobody is going to notice it as much as you notice it yourself. I assure you.
And Brittany is definitely right. I'm sorry. Sorry. Anyway, Brittany's definitely right. Because I have done the same thing. I was speaking. Everybody knew I was on defense, and I was going through my open at the time, and I said, "You're going to find him guilty at the end of that." And I was like, "Oh, no, we're not. We're going to find him not guilty." So, I mean, it depends on the situation that you're in. It can be more obvious than others, but sometimes just don't highlight it. Just move on, and it'll be all right.
I'll jump in there. What's helped me in the past, and this is for everyone, is just to make an outline. So if I write down verbatim what I think I'm gonna say, it does trip me up a little bit. But also, I think I'm able to think more on my feet and just focus more on like passion of what I'm saying. This advice goes for everyone, but at the end of the day, what you're putting on is a performance. And when you start looking at it that way, you can start thinking about, okay, what's going to get the jury's attention? What are they going to focus on? How am I going to keep them listening and not just zoning off and thinking about other things? So those are just a few points for everyone to focus on.
All right, cool. I guess, Deidre, you said you wanted to go next.
Okay. Ladies and gentlemen of the jury, first, thank you for being here. Second, I'd like to apologize for wasting your time. I'd love to wow you with a great story, but there's not much to tell. What you'll hear today is that on the morning of March 8th, 2021, my client was in an argument with her husband, and that a man is dead. Think about that for a moment. That's it. That's all we know. And it's not enough to find my client guilty of anything. Because no one here has ever been in an argument, right? I remember the first time I received a bad grade in school. I told my best friend, oh my God, my mom is going to kill me when I get home. I arrived at home. She yelled, she screamed, she yelled, she droned on. And then she went into my closet. She took my dolls and kept them until I brought up my grade. I was scared to death. But one moment, murder has to be proven beyond a reasonable doubt. I assure you that by the time this is over, there's no doubt in my mind that the state will not be able to make its case. Thank you.
Well, you were direct to the point on what you were looking for. You said what the burden is, which is very important. You may have crossed the golden rule by saying no one here has been in an argument. I remember when you didn't quite, because you didn't tell them to remember the last time you were in an argument. Were you in fear for your life? Did you really think that it was going to end? You didn't go that far, but you kind of did. So you just be careful, because you may get an objection on something like that. I would suggest maybe personalizing your client a little bit more. Because you called her your client and you never said their name. And the whole idea is to get the jury to like your client, not just that they don't have enough evidence to do anything. There's no facts. I mean, I like the fact that you brought out there really wasn't enough facts in this case for us. But say their name, that Judy Johnson or whatever we're going to make her name over here, there's no facts. There's nothing. We have no facts other than they had an argument that day. So.
Thank you. I literally just threw this together as I was talking to everyone else.
Hey, that's the important thing, is you try. The more you do it, the more you practice, the more comfortable you get with doing it. Because in real life, you don't get all this time that you'll get in law school to prepare for these things. In real life, especially if you're doing criminal work, you probably will get just that as you're walking in time to argue something, not a trial, but argue something in front of a judge with hardly any background. So most of it is really quick preparation on things. So that's a good skill to hone, just doing that. That's an important skill. It's a good job for that.
And I'm gonna give you the feedback, the lens of you just throwing it together, and I kind of like it. I kind of it was direct. It was when you first started, you kind of personalized it, and I like personalizing things, making it unique because it sticks out in the jury's head. It makes us think that we are all humans. We could all be in a situation like this, and it doesn't. When you personalize it, it helps you get to that area where around the golden rule without going over the golden rule. So you can. That's how I like to do it. That's how I like to avoid the golden rule, as Ms. Sam said. I definitely like that aspect of it.
I'll say I like your speaking voice. I think you're a very confident speaker, which is really great. Naturally, you're very confident. The only thing I would say, and this may just be me, but I would be careful saying, "Oh my God," only because you're in the Bible Belt. I don't know how that's going to be perceived. And you may have a jury that was like, I can't hear anything else past those words because that's the Lord's name in vain. And I'm not even religious, and it stuck out to me. So, and that's just from coming here to Tennessee and seeing how many people, are hardcore, like you just can't. So I would be careful of your audience, depending on where you practice. Some places you can probably get away with that more. And that's just the only thing that really, like, the minute you said it, I was like, so. Okay.
Yeah, Rachel makes a good point. To us, that seems very it almost feels pedantic to talk about, because it is like everybody says that, but you never know when you're going to get that one person in real life, or even that one person in like a competition that is going to be very, very peculiar about something that never got questioned in like the voir dire or anything. So I think that it's almost like you want to make it super interesting and like punchy, but then also like, okay, but I have to talk to the most boring person ever to make sure that I don't make them upset about this. So yeah, but I thought you did great, Deidre.
I like her little yay.
That's what I was just, it was so cute.
All right, who's next? I think
Matthew.
Isn't Katie? Isn't
Matthew in the chat said they wanted to do defense.
Got you.
Very good. Can you hear me?
Oh yeah.
Oh boy.
You have
You
feedback.
You better get a bit of an echo.
Echo. I don't know what to do. Let me turn down the volume on my headphones a little bit, see if that helps. Am I helping at all?
No.
Not at all. Is it unbearable?
It's like there's several of you. It's a huge echo.
Yeah.
Oh,
It
Lordy.
might be because multiple people have their mics on, and if their sound is really loud when he talks, it echoes back. Because we had that problem during competition last week.
True.
Good point. Yeah. Let's all make sure that we're muted, just because. Yeah.
So testing, is that any better? No. Let me log out, and I guess Katie can go, and I'll try a different headset and see if that helps. Okay, I'll try that.
He sounded like he was in space.
Yeah.
I liked it.
Gotta love a good technical difficulty. It always happens.
Could start off on no planet is this a crime.
Are you ready, Katie?
Actually, I started writing mine at the beginning of this session.
That's okay.
And so I am almost done. I would definitely be done by the time that Matthew was done, which is what I thought was going to happen. So sorry.
Okay.
It's all good.
Oh yeah, I wasn't sure what direction to take, and so I was actually just planning to come and listen, but
Yeah.
you said that we could take a shot at it even if we hadn't prepared it beforehand, so I'm giving it a shot.
This was the first time doing this. So now like we've learned we need to say who the plaintiff and defendant is. We need to
Yeah.
say the charges, but it's new for everybody. And we're working with you, you're working with us. We'll get there.
Learn, we live and we learn.
I apologize, you guys.
Otherwise it was good.
No, I think a limited fact pattern can be good because you never know how much information you're actually going to be given in anything, right? So like I know in the perfect like capsule world that we do for competition, everything is kind of laid out for you to pick through, but you're not always going to have like good facts or good like circumstances that your client comes to you with. Like it might be like Cindy Johnson, who Grant went with at the beginning, who has these weird charges, and you're like, okay, what are they basing them on?
I think we could work together to put together an outline for both sides and post it afterwards.
I can definitely do that.
And by me, I mean Wesley.
All right. Cool. That works. I was voluntold.
Matthew, you want to go ahead and try to go?
Is it any better now?
Yes. Night and day.
Oh, good. Good. All right. So I didn't prepare anything because I'm the worst. So I'm just going to shoot from the hip and we'll see what happens. Okay. So I'm going to argue on behalf of, and the chat disappeared whenever you logged in, but that was Deborah Johnson. Is that who we're going by?
Yeah, I put the name Debbie. You can
Okay, Debbie Johnson. Very good. All right. Good afternoon, ladies and gentlemen of the jury. My name is Matthew Tuttle, and I am here representing the defendant, Miss Debbie Johnson. On March 8th, 2021, a tragedy occurred in the lives of a wife, a child, and all those who knew and loved Mr. Johnson, as he was found dead at the result of a gunshot wound. The state is going to argue today that my client, the defendant, Mrs. Johnson, shot and killed her husband as a result of a marital dispute. The state has the incredibly high burden of proof of beyond a reasonable doubt that they must show that it is clear and convincing to the point of which there is no question whatsoever that Mrs. Johnson shot and killed her husband. The key evidence that the state is going to try to show is that there was an argument, that there was a dispute. Miss Johnson, while in this argument, was rummaging through her closet, and then after the argument, drove off at a high rate of speed. What you as a jury are going to have to determine today is whether a marital dispute, having an argument between spouses, people who live together and love each other and have very strong differences of opinions from time to time, if an argument, if looking through a closet and driving off in frustration after an argument equates to evidence clear and convincingly beyond any reasonable doubt to murder. That's what you're going to have to determine today, is whether a spouse in frustration driving off at a high rate of speed shows guilt of killing their husband. I appreciate you being here. You fulfill an integral part of our justice system, and I trust that as the evidence is shown and the state fails to meet this high burden, that you will find my client, Miss Johnson, not guilty of the charges brought here today. Thank you.
Very good, especially since that was off the cuff. That was very good. I really liked how you kept it so simple. You said the three main pieces of evidence that they have and said it in such a common everyday way that it was like you were attacking it, but it didn't sound like you were attacking it. You said it in such a way that you really made, if I was sitting there as a juror saying, well, that's ridiculous, just such a good job. I really like how you kept putting the burden on them. Are you an L1? Okay, so you may not know that although they have the burden, it's not no question whatsoever. You can have a question and say, okay, that's taking a little bit too far, but I think you did a really, really good job. I actually, other than that, which you haven't, you're an L1, so we're going to forgive you for that. I thought it was perfect. I mean, I thought you could have done that in front of a real jury today.
Thank you very much. That's very kind of you. Thank you.
I love your timing when you talk. Like you have great timing, great pacing. It was very just calm and laid back, but in such a way that Grant said it best. It was like butter. When you
I liked it, and especially since it was off the cuff. It was and like you kind of eased into it. It was like a glove. Like you just kind of it was great. Um, you definitely got the story. You laid out what happened. You laid out the burden, and then you talked about the evidence, but you didn't talk about it in in an argumentative way. It was like you're gonna have to decide that this evidence amounts to beyond a reasonable doubt, and you did it without saying that, and it was really good. It was really artful. So, and it just seemed like you're just really comfortable speaking. I guess I'm guessing you have a lot of public speaking, background. I guess
I have a little bit.
yeah. So it's just one of those things that you can't really teach. Like some people, the more they do it, the better at it they get. But then there's those rare people who can just get in front of a crowd and just kind of ease into it, and that's kind of how it was, and it was pretty cool.
Well, you're one of my favorites, so I appreciate it. Thanks.
Well, thank you. I thank you. You flatter me.
he doesn't need that.
True. I don't know, but sorry, y'all.
I think that brings us to just Miss Johnson, right?
Yes. So again, I just started writing this at the beginning, so sorry. Okay.
Can you turn your camera on, or if you can't? Oh, there you go. Yeah.
It's been giving me some problems today, so I'm sorry if it does anything crazy. Members of the jury, imagine being in school again. Every opportunity at your feet, but a period with its own special challenges, if you'll recall. Now imagine you wake up on a Monday morning to face those challenges with the sound of your parents arguing ringing in your ears. They get louder and louder. You hear your mother tell your father to get out or else she would make him regret it. What does that mean? You head downstairs to see if everything is all right. The body language in the room is tense. Your father is sitting on the couch, arms folded. Your mother, who has just promised to make your father regret the very thing he is now doing, is rummaging in a closet that you know contains a gun. But you left that tension to spend the day at school because no part of you could imagine that she was looking for that gun, or that she was planning to shoot your father, selfishly taking him away from you and your family forever. Murder is an act committed by another person that results in the death of another, committed with malice and forethought. We have 3 witnesses who have come here today to speak with you. One witnessed Debbie Johnson taking her husband's life. Even another saw a woman fitting her description fleeing the scene. The last, Debbie's daughter Cindy, can place Debbie Johnson herself at the scene of the crime, making malicious threats against her husband and then conducting a thorough and thought out search for a weapon to carry out this threat. It is my hope that we will show you beyond a reasonable doubt that Cindy deserves justice for her father and for herself. Members of the jury, I ask you to condemn this gruesome act of domestic violence. Let this community know that we will not stand for settling marital disputes with bullets and pain. We are looking to you. Thank you.
I thought that was very persuasive. You told the story very well, very dramatically. However, you absolutely violated the golden rule. You absolutely said, put them in there, making the jury see it from their perspective. I think you could have tweaked the words just a little bit so you weren't telling them to. You could have just told the story from Cindy's perspective and left it like that. But you told the story very dramatically without being argumentative. I thought that was a really, really good job. It got your attention right off the bat. I paid attention. It wasn't until the very end I realized that you never told us that you were for the prosecution. And that's what I realized at the very end when you said that. It's like, oh yeah, okay. Because you got my attention from the very beginning and kept it the whole time. Pace was good, drama was good, facts were good. That was good.
I like,
Yeah.
So sorry, go ahead, Brady.
Oh, I was just gonna say, the reason that the golden rule is the golden rule is because it works so well. Like that, the act of putting somebody in the seat of like a victimized like person is it's almost always gonna win over the jury. And because of that, and because it might diffuse like the facts from the emotion behind it all, which you're trying to do a little bit anyway, just through your job. But because it's so effective, that's why it's not allowed. Just to put some context on why the golden rule is the golden rule. Because it works too well.
I wasn't sure where to kind of delineate it. We just started talking about the golden rule in class. And so it was like, I wasn't sure if it was like you like don't ask them to put themselves in their shoes, but like to imagine that they're themselves in the situation. So I wasn't sure like where exactly that could fall. But thank you. This is very helpful actually for this and class.
Bro, there's a lot to be said about someone who can paint a picture. And with how you crafted your open, especially, you know, how it was just kind of, you know, you just wrote it. I liked the picture that you painted. You depicted a high stress environment that someone was having to navigate through, and you know how it weighed heavy on them as they're leaving the house, and you know you put everyone in the mind of the daughter Cindy. And you know I feel like if you had more knowledge at that while you're writing it as to, you know, how to not cross that line to the golden rule, you would definitely not have crossed it. You wouldn't have needed to, because you did a good job of painting the picture and telling the story. So that's really good.
Thank you.
I just noted one thing. I've had my camera off because the dog is distracting. You said, it is my hope that we will prove to you. You want to be convicted, you know, in your statement, and you say, we are going to prove to you. You know, you got to believe it. You can't just hope. You got to believe it. You got to appear convicted. And so that's just one thing that stood out to me. Otherwise, add a girl, pulling it together on the fly.
Thank you. I actually had that down at first, and then I was like, is that conclusory? Like, can I say that? And so I switched it, but okay, good to know.
Yeah, you can tell them exactly what you're asking for. One thing that I will say, since you're the last person, is the theme. So one thing that would have been nice, and I think your side allowed for a theme a lot easier than the other side, like maybe something like, you know, today's all about little pieces, these little moments in time that seem like nothing. But then when you take them and you put them together, so you have this car speeding away, you have the fight in the morning on the couch, you have the mom being seen inside the closet where a gun is kept. It's all these moments. When you put them together and you look at this entire picture, these little moments tell you what really happened. So something like that, it kind of paints the story. And so you'd start off saying, this is my theme. And then as you go on, you kind of hit on little pieces, like this is another little piece. This is another of those tiny little things. And then as you get to the end and you're like, now let's bring full circle. All these tiny things, when we add them together, this is what you're really seeing. This is one big picture that tells the entire story, not so tiny anymore. So that's the only feedback I think that goes for everybody, really, is that I would try to pick a theme. And sometimes you won't have a theme, but whatever you do pick, same for opening and same for closing, keep that theme the whole case. Unless you're switching to the other side, then ignore what I said. But otherwise, I think you did a good job.
Bailey just posted in the chat, great work, everyone. I'm sure you can see this, but for anybody who's not like actively looking at their computer, Bailey posted, please feel free to reach out to anyone if you have questions in the coming days. Our closing workshops will be March 22nd and the 25th from 4:30 to 5:15. So same time, same place. We're using the same link. And we're holding an open house on March 27th at Schultz-Brow from 2 to 4. I think that kind of wraps us up for the day, unless anybody has any other feedback or questions before we go. Just opening the floor.
I just want to say I appreciate you guys for coming out here and just doing this. This sets you apart from all your other classmates. You guys, I feel like anybody who can get up there in the courtroom, anybody who can actually has the confidence to actually go out there and try a case, step into the arena. It sets you apart and makes you a better lawyer. And again, not everyone is built for this, or I guess not every case can go to a courtroom, but not every lawyer can go to a courtroom. And if you hone these skills, if you get better at it, I promise you, it pays off in the end, and it makes you a better attorney. So good job, guys.
One thing I will say is if you have the opportunity, either in person or even via Zoom, to practice in front of your friends, I know that helped me the most, especially for like the first competition that we did, because I sat in front of Grayson and Sarah, who you guys don't know. And the first thing that Grayson said to me was like, you need to back up, you're too close and I'm uncomfortable. And it was like little things like that are not your content, but their style. And those are really big pieces that are so important and you don't realize it. And the other thing that Sarah said was like, breathe, just take a second and breathe for me. Because I was flying 1,000 miles a minute and I didn't realize, because your anxiety is so high, you're going on a high. And so it's little stylistic things that you learn from your friends in your feedback, because they'll be honest and they'll say, hey, I wouldn't say that, or I would word it differently, or this is how you came across to me. And that, the content, yeah, it'll come, you'll get it as you learn it in class. And those are easy pieces, but it's the style and the presentation, I think, that really makes or breaks it. And so your friends are probably your best ally. And Celia, tell your dog I love him, Katie said. I do see him in the background. At first I thought he was wearing the shirt. There's like a green shirt and I thought he was dressed, and then I saw him move. But yeah, so anyways, you guys did great, and I'm proud of you for taking the first step and just getting out there and not being afraid to fail, because we all do it. And good job on you.
I have a question. So I know that you guys are going to, put out some sort of outline for us to take a look at. And it's also been recommended that we take a look at some videos on YouTube. I haven't done that only because I know what my left-right limits are. I wouldn't know what a good video would be versus a bad one. So I would hate to take pointers from something and I thought, oh, well, this seems pretty cool, when it's like, oh no, those are all of the things that you should not do. So is there a video series or something that you would recommend? Do we have even, our own candidates that have, participated and, that have, put some examples out there that we can take a look at?
I would say here's one that I know for a fact is a very good one, and it is the prosecution's opening in the George Zimmerman trial. Go watch that one. That one, it's got everything that you would want. It's got a very strong beginning. It sets the story. It sets their theme, and then it goes into the law, and they talk about what they have to prove, and it's very captivating. And I'm not a big prosecution guy. Everybody knows that I'm a defense-minded person, but man, when it comes to that was a good one. So I would watch that.
One thing that I used when I was kind of doing my first like opening, and then later on in competition, I went and I searched for like lawyers or law schools that put out videos. I believe that one that I used was John Marshall, because they just have like an educational like series that they put out that gives you like an outline of the elements that you're trying to hit in the opening, as opposed to like an example of the opening. I know that like examples are definitely helpful for understanding how to put it all together, but that outline giving you the actual elements of what to hit is so helpful if you need that for your first time. So maybe look that up. If I find anything, I'll forward it to you, or I'll like send it out or post it. Okay.
I have it memorized if you guys want a quick rundown. I always start with a theme and theory. And then you go to the intro. So like, oh, my name is Celia Ball, and along with my co-counsel, Mr. Wesley Ecke, we have the pleasure of representing, and after the intro, we go into the story. And the intro includes not only us introducing ourselves, but introducing our client. And I always like to tell a little, I tell their name and a little bit about them, where they're from, where they go to school, what do they do, what their hobby is. Then you go into the story. I know like in a recent one I did, it was like, and then on that day, their life changed, and they say, let's go back to that day, and then you're breaking it down. And then after the story, you go into the support of your theory. So that's where you break down and say, what happened that supports why you thought, like we had a car wreck one, and we were like, well, he had a previous car accident, or, he wasn't wearing a helmet, he didn't have a license, what, you bring in, and you don't want to bring in every little detail from the fact pattern, but you want to pick the ones that are most crucial and most relevant to your theory. And then after you go through those supports of your theory, you're going to end talking about your job. So your job, the burden of proof, and then, whatever crime you're talking about, or in a civil suit, like, negligence, for instance, you're going to break down the elements of that crime. And like, so negligence for duty, breach, causation, damages, and you're kind of explain to those what those are. And when you're doing that, you also want to do that in very like layman's terms. Like, I was told like you're talking to a fifth grader. Like, you want to be very like, you don't want to use big fancy words, and you don't want to use legalese, and same way, like when you're making objections, make it for a jury to understand, even though you're in front of a judge. And then, you'll wrap up saying, at the end of this trial, my co-counsel is going to ask you to find in favor of whatever side you're on. And then throughout that process, you go from, theme and theory, intro, story, supportive theory, and your job. Throughout that, you want to find little odd places to throw that theme in. If you have like a catchphrase or a catchword, I only know like my own examples that like Nathan and I use, when you snooze, you lose on a case. And so we would throw in there, like in our supportive theory, well, they ignored all these warning signs, and when you snooze, you lose. And I think, who was it that did the storytelling about digging through the closet? One of them that was in here.
Deidre.
About, was it, okay. I love the storytelling. I think Wes said that too. Like, I've done things like where said, when you snooze, you lose. And I gave the example of missing breakfast because I hit the snooze alarm too many times. You make yourself relatable, and that's really important. You want to be personable. And I personally have had the problem. I was told earlier this semester, less hokey, because I love to turn on the newscaster voice. And because I have a very strong public speaking background, and that's what I'm used to, is that very like, and on WBIR today. So you don't want to do that. I know Grant did a really good job of that too, and Deidre and her sass, but keeping everybody engaged, entertained, but keeping the statement unified. Like, we're not smooth transitions, not being boring, and you got to kind of spice it up when you transition to each, because if you ever sit and listen to any of these, you get about 3 minutes in and you're like, okay, I'm ready for the next one. If anybody can relate. I don't even like listening to myself for that long when I'm doing an opening statement, but yeah, that breakdown makes things much easier and simpler, and helps you keep things organized.
Yeah, thank you.
Mary, do you have anything you want to add?
I just want to say I have to get out of here. I wanted to thank everyone for participating. I think that was a great first try out of the box for all of you. And the more you do it, the better it is. Even if you don't want to compete or anything, it makes you more well-rounded attorney. There are a lot of attorneys that don't ever go to court, but at some point or another, you're going to have to speak to people. So it's helpful to learn some of these skills. Thank you and good luck.
Ms. Sams,
Thank you.
thanks for being with us. We really appreciate your time.
Have a good spring break, everyone.
Oh yeah, happy spring break, guys.